In fact, in every year while filing its report, the company must also specify the total number of shares which it is forfeited in every annual returns and submit it with the register of companies with respect to that of the forfeiture what the company has effected. So my friends, we see that this all this would be a effect on that of the person on such forfeiture of shares, and he would lose one hand, he would lose his right of membership. But though the liability is there, but the liability shall stands to be remaining for 1 year, and he can also be imposed with the penalty and expenses what is being made in respect of those shares which is being forfeited by the company. The next is a small topic which is surrender of shares under section 67. That is, when the shareholder of a company gives voluntary of his shares in favor of a company, he is said to have surrendered the shares of a company. In fact, the company, instead of going for the forfeiture of shares, it may also give a call to the shareholder for surrender of shares. In fact, the Act does not contain any provision to this effect relating to the surrender of shares, nor no powers are being conferred to accept this surrender. Because once if the company accepts the surrender, it may possible to show that the company is purchasing its own shares in the company. So this has been, which has been prohibited under section 67 of the Act, saying that the company cannot purchase its own shares. However, the articles of a company may prescribe and give certain power to the directors to accept that surrender. That is, if it is in terms of the articles of association, then section 68 provides a power to the directors to purchase its own share from that of the members in certain circumstances. That is, on the surrender of shares, and that surrender would be considered to be as valid one. One, that is the first one, in cases of a partly paid up share where forfeiture is called for. That is, if the directors are given a power to accept the surrender of shares, and this is because to save the company from foregoing through all those formalities of forfeiture, then it may accept for the surrender of shares. Other than the circumstances, it becomes invalid. Surrender has practically the same effect of forfeiture, but only thing we see is that share or the shareholders is not liable to that of a forfeiture as it is unlawful. It relates to the number of shares holders from the liability in respect of shares. It does not amount to a purchase of its own shares, and also it is something which the company is reducing its capital with the permission of the court. This is the first thing we see, or first procedure wherein which we can consider that the shares are surrender of shares are valid. The second one is in case of fully paid up share where it is exchanged for the new shares. My friends, we just understood that what if in case of surrender of shares when it is partly paid up, how the company can proceed in accepting the partly paid up share. But whereas if it is a case of fully paid up share, then where the surrender is in accordance with the article accepted by the company as to the fully paid up share, then it should be only in respect to the exchange of new share of the same nominal value. The surrender of shares remain to be capable of reissuing, and that surrender is valid in where it has been accepted by the company for the issuance of new shares or in the place of new shares. But the question comes is this: can a company purchase its own shares? In fact, the company may purchase its own shares other than the specified securities hereinafter referred to as buyback securities. That is, where if the company has issued a buyback securities, then the company can take back those securities which would be amounting to a purchase of its own shares. But there are certain restrictions, like when the company is by getting its buyback securities, it should be brought only through that of its free reserve or the amount which has been kept in security premium account, or where the proceedings of issue of any shares or other specified securities specifically mentioned for the purpose of having buying back those securities, provided which says no buyback securities of any kinds of shares so specified in cannot be made unless otherwise of these amount. So also the second important thing we have to know in case of can a company purchase is that no company can purchase its buyback shares unless where the buyback is authorized by the articles of association, and there is a special resolution has been passed to this effect in a general meeting authorizing the company to buy back those shares, which is of a nature of buyback 1. The third one is the notice of the meeting of special resolution should be proposed and passed it shall be passed by the company, that is stating out the full complete disclosure of all material facts, necessity of buyback, the class of shares or securities intended to be purchased, amount to be involved in, and the time limit in completion of this buyback shares, and every buyback shall be completed within 1 year of having passing the resolution. So subject to this, the company can proceed with the buyback shares. And one another important condition, especially with the buyback shares, is that is in case of buyback share, the existing shareholder or the security holder, it shall be made on proportionate basis. Then if the shares are from open market, it can do so. Purchasing of securities issued to the employees to the pursuant of the scheme or the provision or the rule provided in, they can go for this buyback share. So also if this buyback shares of a company has to file with the register of companies and also with the security contractors in terms of security contractors regulation act, declaring of any solvency and signed by at least 2 directors, of whom one would be the managing director of the company. The company so buying back the shares, that is its own shares, is shall literally or physically destroy so the shares which is being brought by way of buyback share within 7 days of the completion of this buyback share. So also the company completes, when it completes the buyback, it shall not make any further issue of the same kind of share, including the allotment of new shares within the period of 6 months. In this regard, the company is to maintain in the registry of books of all those shares what it has been brought back or buyback of those nature of buyback shares, and file it with the register. And if there is any default committed in this, then the company and every members shall be liable for not less than of 1 lakh of rupees fine for the default that they have committed in respect of any act which is committed in respect to the buyback shares. So friends, only in this regard we shall see that buyback shares can be brought. In fact, that is the reason why we said under section 68 there falls an exception saying that the buyback shares can be brought by the company. Another important discussion under the chapter of shares is the reduction of share capital. That is, once when the company has called upon for its shares, it would have exhausted that capital what is being specified in the objective class of a company, in the capital class of a company. So such being the case, can a company be allowed to reduce the share capital of which it has issued? My friends, the provision of section 66 of the Companies Act provides for reduction of share capital. That is, reduction means where any act of decreasing the burden of a company is generally understood as reduction of share capital. But this decreasing of burden of company cannot be allowed, or where a company cannot be reduce the capital without the sanction of the tribunal and without the approval of the creditors, and if it does so, it amounts to the deceit on the part of a company. But on the basis of public policy, the action can be resulting in the reduction of share capital of a company which is being permitted unless where it is made under the statutory authority or by the act of forfeiture, or it shall be strictly in accordance with the procedure has laid down under the Articles of Association, and this reduction shall not be contrary to the principles of Companies Act nor with that of the provisions laid down under the Articles of Association. That is, it should not be an ultra virus one to both the company and also to the Articles of Association. The company law also provides in providing a protection and less strict procedure for the reduction of share capital, that is under section 66. That is section 66 lays a procedure for a statutory principles that has to be applied to a company where it is limited by shares or limited by guarantee having a share capital. That is, without prejudice to the general powers of the company may reduce its share capital. That is, by way of 1. By extinguishing or reducing the liability of any member of a shareholder in respect of which no call is being paid. For example, if there is a limited company having a share capital consisting of share of rupees 10, then only 6 rupee of the shares are being paid up by the shareholder. Then if the directors feels that it would not require the further amount of rupees 4 which is liable to be paid by the shareholder, then the company may extinguish its liability from out of the shares which is required to pay upon with and convert these shares into a 6 rupee share. So in such case, the company may reduce its capital. The second one is by cancelling any paid up share capital which is lost or unrepresented on the available assets of the company or for the available assets of the company. Example, where if suppose say a company has suffered with heavy trading loss, then in such cases if the shares are being paid only of rupees 2 on the share value of rupees 10, then if the company converts these shares of 10 rupee into 2 rupee, then the shares to that effect of shares, the company would be effecting a reduction of its capital. And the third one is by paying up any unpaid share capital which is in excess of want of company. Example, like when a C company limited have an equity capital of consisting of 10 rupee share which is fully paid up, the capital is in excess of the requirement of the company. So in such cases, the company can return partial of this amount and thereby convert these shares into the amount of which the reduction is being made. Thereby the company extinguishes the liability of the shares and become the shares of which the amount to the extent of which it is been reduced with. So in all these three ways, my friends, we shall see that the company can proceed for the reduction of share capital. But the mere matter of forfeiture of shares, reduction under the scheme of repayment of preferential shares after amalgamation are not a reduction of share capital. But the other hand, the surrender of share or loss of capital of reduction of share capital can be considered to be as a reduction of share capital. So, however, when we see that the company is allowed in certain circumstances to reduce down its share capital, but this reduction is subject to certain procedure laid under section 66. That is, first part of this is that the company's article should provide a right on the part of the company and also on the members of a company to have a reduction of share capital. Where if the company article does not provide a right, then the proper recourse is for the company is first bring an alteration to the articles of an association, pass a special resolution to this effect, giving a power on the part of the member, that is directors of a company, and then proceed by passing a special resolution for a reduction of share capital. So what we understand here is that even though where the company has no authority conferred in the articles of association, then by bringing an alteration either to MOA or AOA, the company can have a reduction of share capital. The second condition or the procedure is that is the shares which are going to be reduced in the company should be authorized only by way of special resolution in the general body meeting of a company. After of which that is passing a special resolution, the company has to make its application to the tribunal. The company shall, so when it makes an application or a petition to the tribunal for the orders confirming the reduction of share capital, then the tribunal, if satisfied that either of the creditors are entitled to object on such so consented for reduction of share capital or the debts having been paid or secured, and hearing those objections, the tribunal can confer upon the right for the company for having reducing the share capital. My friends, when I say it is a petition filed before the tribunal for reduction of share capital, for permission of orders of for the reduction of share capital, the tribunal shall give due regard to the interest of the creditors of a company, shall give due regard to the interest of shareholders of the company, and also would look into the liability of any members, what would be the effect of their reduction of liability to the company. Looking to all these things, the company may proceed for having reducing down the share capital of the company, that is by the orders of tribunal. So generally the reduction of share capital takes place with all this procedure met with, especially it is with the permission or orders of the court or tribunal. But in some of the few other cases, there is an exception where the company can proceed for reduction of share capital even without the sanction of court. That is only in certain cases, or only in cases of such decrease of its capital, we can understand that it would not be necessary for the company to go with the reduction of share capital without the sanction of the tribunal. So in such cases, the company may proceed to go for a reduction without any such orders, but complying with the procedures, remaining procedures, what has been conferred under the act. So how reduction of share capital can be made without the sanction of court? The commonest procedure where the company can go without a sanction of the court to reduce the share capital is one, the act of forfeiture of shares. That is, the company, when it is authorized by this article to forfeit the shares for the non-payment of calls, as we understood, this results out into the reduction of share capital. In such cases, the company need not require to obtain the permission or with the orders of the court. The second one is that where if it is a case of surrender of share capital, that is company, if it accepts the surrender instead of forfeiture of shares of those partly paid up shares, to so as to save the foregoing procedures in respect of all those formalities to the forfeiture of shares, then the act of surrender would also be one of such where it results into the reduction of shares without the sanction of court. And the third one is by cancellation of shares. That is, the company, if it's so authorized by the article, can cancel the shares which has not been agreed to be taken by any person, and this would be having a diminution of amount to that of the share capital of a company. In fact, my friends, in our regular classes, I had discussed saying you that under the objective class, under the capital class of a company, that the capital class of company would specify the time and date, the time and year in which the capital would be brought to the company. And I was also speaking to you with the minimum subscription, and we understood that at least the 90% of the amount what is being called as a public issue, if not been collected by the company cannot go for the issuance of shares. So where if the company has received 90% of the subscription of which the call is being made from the public, and then the company can go proceed for an allotment of shares, but the remaining 90 and above percent, whatever is left out, would be acting as a reduction of share capital. Thereby, to the effect of this, the company can proceed for cancellation of those shares. This is the third one. The fourth situation is when the purchase of shares by the company under section 241, which speaks with the oppression of the company. That is, where the tribunal have ordered the company for that the case of oppression is made out in the company, then the company can proceed for having reducing the share capital in order to decrease the burden of a company subject to the provisions of the rules imposed in respect of the reduction of share capital. And if not this, then the next one would be the redemption of redeemable preferential shares. The company may redeem the preferential shares, redeemable shares, in accordance with the provision that is provided under in, which gives us an exemption for a company to get back its shares. Of all these things, I can add one more thing, is that is buyback shares under 68, which falls as an exception, which was introduced. That is, the company can purchase its own share subject to the fulfillment of the condition for of a buyback shares, and this buyback share would in a way becomes a reduction of share capital. So friends, in all these circumstances or in all these cases, we can understand that the company can proceed into the reduction of share capital without the sanction of the court. But otherwise than this, if the company proceeds for having reducing the share capital, then without the orders of the tribunal, the company cannot proceed into the reduction of share capital. So once when the company reduces its share capital with the sanction of the court, or in some cases without the sanction of the court, what would be the effect of this reduction of share capital? That is, what would be the liability of the member in respect to the reduction of share capital or to that of the reduced shares in the company? We understand this as a consequences of the reduction of share capital in the company, the liability of a member in the company, whether past or present, shall not exceed the amount of the difference of paid up value of the shares and the reduced value of the shares. That is, every person would become liable to the amount of difference between the paid up value of the shares and reduced value of the shares to the extent that one, where a person who is a member of the company and the date of the registration and the order of reduction. Or the second one is, if the company is wound up, the creditors may give proof of his ignorance and may apply to the tribunal for the same. In such cases, the liability would be in accordance to the difference of the value amount. But I would also like to bring down in one another issue is the creditors, where what if the creditors are ignorant of the proceedings? That is, sometimes the creditors are entitled to object the reduction of share capital of a company who may be ignorant of the proceedings for the reduction of the shares or the capital in the company. And in such cases, my friends, where a company after such reduction of capital, if it is unable to pay the debts, then the following procedure has to be complied with. That is, 1. Every person who is a member of the company on the date of registration of the order of reduction and a minute is being drawn to this effect shall become liable to contribute for the payment of that debt what the creditors would incur in. But the contributories so made shall not exceed the amount which he would be liable to contribute with. This is the first relief what the creditors would get. The second one is that if the company is owned up, then the creditors may give a proof of their ignorance and apply it to the tribunal. The court may, if it thinks fit, and it can settle accordingly and list out the persons who are liable to contribute to the payment of this creditors. So subject to this, the liability can be imposed in. And what if you contravenes with this, it results out into the penalty. That is every such person who contravenes with this is liable to be imprisoned for the period of 1 year with fine or with both. That is where a person knowingly cancels the name of the creditor entitled to make an objection for reduction of share capital, or where a person knowingly misrepresents the nature of amount of debt claimed by the creditor, or if he abates or privacies to such concealment, privy to such concealment, then in such cases, my friends, the penalty is imposed against the person for the period of 1 year and also with the fine or with both. So friends, these are some of the issues which I can speak to you with the shares, like what is shares, nature of shares, how application allotment takes place, how the company can transfer upon the shares, how the company can proceed for reduction of shares, what is the procedure for forfeiture of shares, and also the surrender of shares. But friends, the one another important, or I can say a topic which you are supposed to know is also the lien of shares, which is not there in this slide. Friends, as soon as we say a lien on the shares of a company by the company, it is something which a right which is given to the company to have over the shares which it has issued with. In fact, according to regulation 9 of the regulation for management of companies provides saying that every company limited by shares shall have first and paramount right in respect of the shares which it has issued, and the lien is always exercised by them, that is by the in favor of a company on all shares where the money so called is unpaid by the shareholders of the company, which means it says the first right over the shares to the extent of unpaid amount remains with that of a company. So this right is something where a charge is created on those shares to the extent of unpaid amount on the shares made by the company. So the company gets a right of lien, and this is a paramount right against all the other creditors who may have a right against the shares by the against the company. But this right of lien is not automatic nor a prima facie which has a right unless the articles provides for a company for the same. This right is also not absolute in respect of partly paid up share except in case where the money is called is payable at a fixed time. So after exercising all this right of lien, the company, if it is authorized by the articles of an association, then may sell those shares with the condition laid down under regulation 10, which says some in respect of the consent shares shall be presently become due and until it is been paid up. The second one is where there is an expiration of 14 days of notice in writing and have been demanding for the money. And when these two conditions are being satisfied, the company shall get a right of lien. So also the article may provide to the company that no member shall exercise any voting power in respect of any shares regarding which his name is on the list of lien and the lien is being exercised by the company. This topic could be probably for a short notes that could be asked for your examination. So friends, this is about with the chapter of shares and how shares are issued. We just made an attempt of understanding the shares, how shares are issued, then what is the right of the shareholder, what all that he can do, and also we spoke with the types of shares, so the nature of these types of shares, then till the reduction of share capital, we made an attempt of understanding all these issues on the topic of shares. Friends, under this slide, I'll be discussing to you with the debentures of a company, which the companies are empowered to issue in terms of Article 246 and also specified under List 1 of the Constitution of India. And we have also understood that the issuance of share is one such usual method of bringing the capital to the company. And the another usual form of having borrowing a capital to the company is through the issue of this debentures. In fact, section 2 class 30 of the Companies Act provides debenture includes any stock bonds or any other securities of the company, whether it constitute a charge on the assets of company or not. But this definition is not an explanatory way what really the debenture is. In fact, in a case of Levy versus Abocaris Slate and Slab Company Limited, the court observed that through Chitty J that debenture means a document which creates a debt or acknowledgement, and any document which fulfills either of those conditions, then such is said to be considered as debentures of a company. Thus, we can understand with a debenture means any documents which acknowledges a loan made by the company and have agreed to pay a payment of interest on such sum borrowed until the debentures are redeemed, then such a document is said to be called as a debentures of company. So debentures are also issued in the same similar manner as that how we issue a share, that is especially in cases of public company through the prospectus. And the amount might be payable by installment or on application or an allotment of calls, but usually the amount is being payable in one lump sum. Let's also understand with the characteristics or features of this debentures. Friends, this debentures are, once it is issued by a company, it is usually, as we understood, it is a form of certificate of indebtedness on the part of a company. So also it usually specifies the date of redemption and also provides for the date of repayment of the principal amount along with its interest. It in fact creates a charge on the undertaking of the company or on some property of the company. And once when debentures are issued under the common sale, it should be issued under the common sale, but it did not, however, be necessary always under the common seal. So the debentures also, that is, the debenture holder does not have a right to vote in the company's meeting. These issues of debentures are issued in the set of the manner of what the shares are being made, but by nature they are different with each other. However, the power of issue of debentures rests with the board of directors. That is, the board of directors would decide to say whether they would proceed to go with the issuance of debentures or not. And once when the board of directors decides to issue these debentures, then within 3 months of the day of issuance of that debenture, there shall be an allotment and a delivery of a debenture certificate. Sometimes the debentures are also issued with the pari passu clause. See, pari passu clause is nothing the terms and conditions on which it is issued with. Usually, the debentures, one issued by the company, shall include a series of pari passu clause. That is, in such cases, the debenture holder shall be discharged with the discharged with the ratably through the issued, and there would be a difference in varying terms. In the event of deficiency of assets to satisfy the whole of the debt secured by the issuance of debentures, then the amount would abate proportionately on those of the debenture holders. Where if there is no pari passu clause, then the terms of issue would be payable according to the date of issue in which it is been effected with or issued with. Next is the classes of debenture or kinds of debentures. In fact, friends, there are 7 kinds of debentures we can come across with: bearer debenture, registered debenture, redeemable debentures, irredeemable debentures or perpetual debentures, secured debentures, unsecured or naked debentures, and convertible debentures. Let us understand the features of these debentures. See, why the debenture is called as bearer debenture is that for the reason the debenture holder who is a person who would be holding this debentures as an unregistered debenture holder, and the amount is payable to that of a person who bears this debenture or who is in possession of this debenture in his hand. These kinds of debentures are more similar like that of a share warrant what is issued by the company, and they are regarded to be as a negotiable instrument because by mere transferability or by delivery the shares or the debentures get transferred to the bona fide transferee, and the value is not affected by the title of the prior holder. The interest of this bearer debenture holder is paid by the means, that is with the attached coupons, that is whatever the interest payable is payable through that of the attached coupons. On the maturity of the principal amount, they shall be payable to that person who bears that of a debentures or the coupons with him. The non-payment of any principal amount or interest entitles such bearer to also for the winding up of company. So this is one class or one kind of a debenture. A registered debenture is so called because these are the debentures which are payable only to the registered debenture holder. The holder is that person on whose name appears to be both on the debenture certificate and the company register. The register holder can transfer them from time where the shares or it can be transferred in the like manner of the shares is being transferred, but the transfer is complete as when the registration of transfer is completed with. It is also required to be noted with that the debentures are transferable in the manner specified and in the condition endorsed thereupon on the back. In fact, the registered debenture holder shall contain the following clauses like the covenant to pay the principal amount, the covenant to pay the interest, the description of the charge on the company undertaking and the property, and the statement is issued and the conditions endorsed thereon to such statement. All this particular should be made in the certificate of the debenture which is holding as a registered debenture holder of a company. The third type is the redeemable debentures. Usually, debentures are issued on a condition that the debentures are going to be redeemed back, taken back after a certain period of time. Such debentures are said to be called as redeemable debentures, and these debentures can be reissued after the redemption in accordance with the provision of the Act. Whereas, that is, if it is a irredeemable debentures, it is also called as perpetual debentures for the reason that when the debentures are irredeemable in nature and forever it remains to be as a debenture where it cannot be taken back, then these debentures are called as irredeemable or perpetual debentures. A debenture is so called as irredeemable where either there is no fixed period of payment of principal amount nor of the repayment has been made on a condition on the happening of certain event or an event, then it may so happen for an indefinite period, or such a case we shall consider that to be as an irredeemable or perpetual debentures. Whereas on the other hand, a secured debentures are those debentures where the creditors are given some charge on the property and the company would be secured with the debtness what they are having with. So it is such debentures are said to be called as secured debentures, and the charge may be of a fixed one or a floating one. The another hand, we do also have an unsecured or naked debentures. These are the debentures wherein no charge is being created on the assets of the company, and they are known to be as an unsecured debenture holder or naked debenture holder. That is, this holder of debentures are like an ordinary unsecured creditors who may sue the company only for the recovery of debts but cannot claim any charge over the assets of company. The next one is convertible debentures. These are the debentures who are given with the option to the holder to convert them into a preferential or equity shares at the stated rate of exchange after certain period of time. That is, the holder can exercise the right of conversion. They cease to be as a lender to the company on such conversion and they become a member of the company instead. The convertible debentures may be a fully convertible debentures also. However, the debentures so issued can also be in the form of non-convertible debentures, that is, where a debenture is of a nature which it cannot be converted or there is no option of converting the debentures into a preferential shares or equity shares, then those are the debentures which are considered to be as a non-convertible debentures. My friends, see, we understand that when any debentures are issued from the company, these debentures are something which would be either as a registered debenture or a bearer debenture, and these debentures would be either in the form of redeemable one or irredeemable one, and these debentures can also be in the form of secured one or unsecured one, so also a convertible and non-convertible one. These four natures we can come across in every debenture, and those debentures are issued by the company. While discussing with this debenture, I have taken the word called charge. What is this charge? See, when your debentures are a secured debenture, which gives a right of charge over the assets of company. So what is this charge? Charge is nothing but the power of the company to borrow includes the power to create on a charge upon the assets of a company, and this charge includes a mortgage. That is, where a charge is nothing but a kind of a right provided to the holder over the assets of a company. The charge so created on the assets of a company may be in the form of fixed charge or floating charge. What is this fixed charge? Fixed charge are such kind of a charge which is created on some specific and definite assets of the company. Example, the company might be having a land, assets, building, property, etc. And if the charge is being created on those specific property, whether it is a particular land or a particular building or of a particular assets, then the charge so what is being created over the property is said to be called as a fixed charge, which by creating a fixed charge, it precludes the company from dealing in the property without the consent of the holder of that charge. So if the company wants to deal with that such kind of a property on which fixed charge is been created, subject to the approval of these persons with whom the charge is created, they can sell the property or deal with the property. The next is of a floating charge. A floating charge is a way it is called as an equitable charge which is created to some class of property which is constantly changing from one property to the another property. Example, suppose say if the charge is created on stock on trade or the trade debts which the company is having with, then those charges are said to be called as a floating charge. In such case of charge is being created, the company can deal with such property in the normal course of its business until the charge becomes fixed on the happening of certain event. So the main idea behind of having issuing a floating charge or creating a floating charge would allow the company to carry on its business in the ordinary course of business in which no charge is being created or as if no charge is being created, and debentures usually creates a floating charge on the assets of the company. So floating charge is for this reason also called to be as an equitable charge which does not fasten the specific property but covers the whole of the property of such category or such class of property, or it is not unless wherein it is not subject to that of a fixed charge. And we say this floating charge when gets fixed, it is said to be called as crystallization of floating charge. So crystallization is nothing but conversion of a floating charge into a fixed charge on the assets charge and on the moment of crystallization. That is, when the company goes into liquidation, when the company ceases to carry its business, when a receivers are appointed in respect of the business of company, or where a default is being made in paying the principal amount with interest to the holder of the debentures, and a charge is being created and an action is being enforced to this as a security. So when any of these act is being found out in the company, then the floating charge what is being made shall automatically get converted into a fixed charge, and that conversion of floating charge into a fixed charge is said to be called as crystallization of floating charge of in a company. So what we understand is this, my friends: debenture is something where it is an indebtedness which is shown from the company which it owes to the creditor or which it owes to the debenture holder. With such debenture, issuance of debentures would create a charge over the assets of company, and that charge could be either in the form of fixed and or floating. And fixed is that the permission is required, whereas in case of floating charge, no permission is required for the company to deal with those properties on which this charge is being created. So from this, friends, we would understand there is something a difference between the shares as well as debentures. To briefly express upon the differences between shares and debentures, shareholder is a member we understand with, but debenture holders are not a member, they are only a creditors of company. So also, except that of a preferential shares, the right to vote is provided in the company in its administration. But there is no such right to vote which has been provided, and section 117 of the previous act I'm speaking, it prohibits with the voting right of any such person in the meeting of a company. So also, as it is a case of shares, income of the share depends upon the profit of the share which it gets with, or dividends which it is to be paid with. Here, when it comes to the debentures, the holder is entitled to a fixed rate of interest which the company is being paid, which is company is required to be paid whether the company gets a profit for the year or not. It is more or less in the form of preferential shares. Shareholder, in the case of shares, shareholder cannot be paid back with the amount except it is a redeemable preferential shares. But in case of debentures, it could be paid back as it is we have an irredeemable debentures also, so it can be paid back only after the expiry of certain period. So the another important difference we can make is that in the event of winding up of a company, shareholder cannot claim any priority unless the creditor has been paid up. But in case of debentures holders, if they are the two secured debenture holders, they can claim priority in the repayment. And the last difference we can make is that dividends on shares does not create any charge against the property. It is only that the company becomes indebtedness. But in case of debentures, interest on debentures is a charge against the company, and it should be deducted from out of the assets of the company. So these are some few basic differences we can make out between the shares and debentures. So subject to these, my friends, we should understand that how debentures are going to be made and how shares are going to be issued by the company. Subject to these, we would understand the debentures. There could be at least one question from each part of the area for your examination. In this slide, I'm going to discuss to you with the dividends. Dividends is one which every equity shareholder during the annual general body meeting of a company would be looking forward with. And we all know this, every investment which a person makes in would always expect some return out of it, which is in terms of profit. And this profit is something which is called as a dividends in a company. So dividends means it is the share of profit of each individual member of a company, or we can say it is when the portion of the corporate profit when it is being declared to be paid by the company to that of the shareholders of a company, then such an amount what is being declared by the company to share the profit of a company is said to be called as a dividend. But one fundamental constraint in respect of issuing a dividend is that the dividend should always be paid out of a capital only and not from any other amount. So do we understand that when the profit of a company is distributed among the members of the company, it is called as dividend. My friends, it is payable subject to the statutory requirements and also with the provisions of the articles of association. So the amounts which is being distributed is in purely a matter of internal management, and it depends with the discretion of the directors and shareholders in this regard. Though we say the constraint is there on the part of a company to declare a dividend only out of profit, but this rule is not absolute in its term. Why I say this is that the company, though having a duty to distribute the profit only out of profit, but in some cases it may also be paid not out of the profit but otherwise than out of a profit. However, there are certain rules which are being imposed regarding declaration of dividend. The first rule is that resolution should be passed in a company in its annual general meeting for the payment of dividend. That is, dividends are declared only through the resolution in AGM. The board of directors would determine the rate of dividend which is to be paid and as recommended by them. The rate is determined by the board and sanctioned by the members in the general meeting of a company. So that what we understand is this, my friends, whatever the amount of profit that the company has received, say example, the company has recorded 70% of profit for an year 2020, then this 70% of the amount is not paid as a dividend. It is the board of directors who determine what shall be the dividend to be payable to their members. The second rule is this: payment of dividend is in proportion to that of the paid up capital. That is, which says when a company pays a capital to you, or when the company is holding a capital of you in the form of shares on which your shares are being partly paid up, then you are not entitled to get such amount as the other shareholder who has paid a fully paid up on their shares what they are holding. So the dividends are paid in proportion to the amount of what you have paid on that of the shares in the company. So the dividend may be unequal and it could also be different among the shareholders. The third rule is dividend is being paid only out of profit, we say. And what is this profit amount? The dividend need not be what the profit has got in the previous year, but there are various sources on which the profit of the company can be distributed. One, usually we understand, that is out of the profit of the previous year which the company has arrived with, provided with the company can have a depreciation to that amount of or from that of the profit. The second one is out of the profit of the company's previous year, which the amount is still in the hands of a company as it is undistributed. Or it could be out of the money provided by the central government for our state government for the purpose of distribution of this amount. In any of the case, that is what how the central government or state government under the scheme they could do so. But what we have to mind is that, see, once when there is a profit in the company, it is not an absolute right on the part of a shareholder to claim for this dividend. This I have already told to you, but still again I'm saying this right of claiming a dividend is not absolute on the part of a shareholder, which says that if there is a profit, the directors or the board should make a resolution, then decide the rate of dividends to be paid or recommended to be paid to the shareholders. In case of preferential shares, the dividends are fixed. The dividends are being paid according to the terms of issue in which the preferential shares are paid are given to them. But the question is with the equity shareholders. The directors should recommend the rate of dividend as they think it reasonable under the circumstances. They may also decide even to not to recommend any dividend on equity shareholders. In such cases, though there is a profit in the company, the shareholders, when declared or when recommended not to pay the dividend, they would get nothing for their investment in the company and no dividends are going to be paid to them. However, we say that once when the dividends are declared, it is a right on the part of the debenture shareholder or a dividend holder to get that amount of dividend what is being entitled by him on its declaration. However, there are certain statutory restriction or statutory provision, I don't say restriction, provision in respect of the issuance of these dividends. One, as I then said, the company shall have a power to deduct such depreciation amount which is being incurred for each and every year from out of the profit of the company. In fact, the Act of 1960 allowed this, that is, depreciation must be provided for the current year as well as even for the arrears which the company has not deducted in the previous year. The rate of dividend of which the company shall go with is with that of the original cost of the assets of the company on the expiry of the specified period in respect of such assets. Where no rate of depreciation has been laid down by under the Companies Act, then the rules made thereunder shall be provided on such basis and it may be approved by the central government. The second statutory restriction is with the compulsory reserve. This was introduced by the Companies Act of 1974 before which any dividend is going to be declared or paid, certain percentage of profit shall be deducted as prescribed by the central government. That is when the amount which the company is going to deduct from out of the profit has a compulsory reserve or to that of a free reserve should not exceed more than 10% of the amount of what the profit that the company has got in that current year. That is, this amount, what the company can do with that of the reserve amount is that in case of inadequacy of profit in the particular year, then the companies can pay a dividend out of this amount which is being kept for compulsory reserve. But in adopting this system, there must be a prior and previous approval of the central government. And the third restriction is that if there is an unpaid dividend account, that is, when I say account has to be opened, in fact, that is, unpaid dividend account has to be made to the cases where if any such declared amount, if not being paid by a company within 30 days as of the new act, if I believe that it should be paid to that of a dividend holders. If that not it is been paid, then at least dividend warrant has to be issued by the company. If either of these two is not being made, then the company has to keep this amount in a separate bank account called to be as unpaid dividend account, and the company shall be liable to pay 12% of interest on those amount which is been deposited into an unpaid dividend account, or such rate of interest has that is been fixed from time to time. And if this amount remains to be unclaimed for the period of more than 3 years from the date of this deposit, then they should transfer it to the general reserve account of the central government, and the person is entitled to claim it through the central government. So in such a way, dividends are going to be made. And the fourth one is that declared dividends becomes a statutory debt on the part of a company. That is, once the dividend is declared, it becomes a statutory debt on the part of a company to their shareholders. That's why in case of Bacha F. Gazdar versus CIT, the Supreme Court observed that a shareholders has a right to participate in the company's profit existing independently as when declared as the dividend by the company. So a declaration is necessary only for the enjoyment of profit, and once when the declaration is being made, the company becomes payable and it becomes a debt due from the company to their shareholders. In fact, apart of this, there is one another class which we also see, that the deposit of redemption reserve, debentures redemption reserve should be kept in the bank. That is, where if the company gets an adequate amount of profit, then that adequate amount has to be deposited into an account for the security of the debenture holders for every year from out of the profit, and the company which is available to be distributed for each and every year. So this is one another class which has been inserted by the new act of 2013. However, in the course of this, the company did not have to wait for the next annual general body meeting. Sometimes the company can also pass an interim dividend by the company. That is, the debt when the company declares an interim dividend, that is in between the AGM, the company can say that this is the amount of profit what the company has received which should be distributed among the members. Then that amount what is set is called as interim dividend. These debts do not create any debt against the company. It can only be declared by the resolution of shareholders in accordance with the director's recommendation at the general meeting. The two, where if the article provides for the company and the directors to declare the interim dividend in between the annual general body meeting, that is 2 annual general body meeting, then this would be declared with. But one has to understand that this declaration of interim dividend does not create any debt enforceable against the company. The directors, in declaring the interim dividend, must satisfy themselves that their financial position in the company is good and the company warrants to the payment of such amount of dividend out of the profits available for distribution. If that is not so, then the directors would become personally liable for the same. So in such way, my friends, the dividends are being made. And as far as the payment of this amount, we can say that is the company shall ensure the prompt payment of the amount, and if there is no prompt payment, then the penalty is being imposed. If the dividend is so declared is not being paid within 30 days of time, nor deposited into a separate account of the person who is holding, then they can be imposed with the penalty. If it is being paid in cash, it should be made by the register holder and declared in the share bank. And if it is a case of warrant, the payment should be made to the bearer of the warrant of this bank.